Says Karen Contreras Hernandez.
Good morning, Your Honor, or good afternoon, Your Honor. I apologize. Michael Burns.
Notice that housing deadlines matter when someone misses them. It's not just a technicality. It can mean losing your home. Think about it. Should a missed deadline carry that much weight in court?
Where I'm going, it's going to turn into morning. But
I hope
anyway,
not.
go ahead.
Michael Burns, P87855 on behalf of plaintiff, Your Honor.
Your name?
Karen Contreras Hernandez.
And what are we doing on this?
Your Honor, this was a termination of tenancy based on violation of community guidelines. Ms.
Yes.
Contreras Hernandez has brought the property into complete compliance, so we're happy to
We
report
just
that it.
needed to wait for her to get from overseas to do that.
Yes, Your Honor.
Because somebody thought I was going to kick out somebody in the military. It wasn't going to happen.
Correct.
Welcome back.
Thank you.
And so I have a dismissal.
Yes, Your Honor.
We're going to be done with this.
Yes, Your Honor.
You have any of that.
No, I do not.
Case is dismissed. That is without prejudice. All right. Thank you very much, ma'am. And again, as I think I indicated to you before, thank you for your service, you and your family.
Thank you.
All right. And it's a pleasure actually seeing you and not on Zoom
Right.
in some faraway location. But I will tell you, as I always say, I get to do what I get to do because of people like you. And I appreciate it.
Thank you, sir.
Court calls the case of Beal Properties versus Melissa Daly.
Case dismissed without prejudice. Translation: they can bring it back later if needed. But here's the kicker: judges rarely throw shade at the military. You're not booting someone who's serving their country, and the judge made that crystal clear.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff. Bar numbers. Yeah.
I guess it's going to be Melissa Daly, Carla Hardman, Cindy Hardman.
Judge Dominic Camden appearing on behalf of the defendant, Mrs. Daly, who's present, sitting to my right.
Okay. Hello.
The counter complaint filed in this case, Judge. We've spoken to each other in the hall and have been unable to reach a resolution in this case.
Oh.
So I do have a procedural question. The complaint to evict is a summary proceeding, but the counter complaint is not. Counter complaint is related to a breach of habitability, as well as breach of the requirement, quiet enjoyment, and then basically a wrongful eviction, which I think entitles me to a certain degree of discovery. And so the question that I have is, you've got a summary proceeding, but you've also got
You're only allowed discovery in district court if I allow it. But
and that's where I'm going.
yeah.
So I'm looking for some form of discovery.
Here's where it gets messy: counterclaims. The landlord wants eviction. The tenant fires back with habitability and wrongful eviction. That's like turning Uno into chess. Suddenly the game got a whole lot more complicated. Which side do you think has the stronger hand here?
On this case.
What is it you're specifically looking for?
Well, the property was left in a significant degree of disrepair, and I think counsel is going to indicate, I'm not trying to advocate for him, but I think he's going to indicate that my client caused it. My response is going to be that it was not caused by my client, that it was basically left in significant disrepair by the landlord. There's also some communication that's been going back and forth from Section 8 with regard to their failure to keep the property in a habitable condition so as to allow my client to enjoy Section 8 and to allow that funding. And so I'm going to want some discovery there as to communication back and forth between Section 8 and the plaintiff.
Response, Your Honor. I don't think I'd necessarily object to the discovery related to the counter complaint, but as it goes for our initial complaint, it involves an unauthorized occupants and unauthorized animals on the premises. It's a pretty straightforward case. We believe our proofs are more than sufficient. As it relates to brother counsel's counter complaint, I don't think we'd have an issue of that, but we'd like to keep our initial complaint on schedule and on track, and hopefully have a resolution or a judgment in it as soon as possible.
So at least on the animal issue, Judge, there's a text message from October 18th of 2023, where they basically told my client she had to have her animal registered. My client responded back with, I told you about the dog before I moved in. She's my emotional support dog, and you were okay with it as long as I got a letter from the doctor. I emailed you the letter from my doctor on April 11th.
Pay attention, the judge is spelling out how discovery really works in district court. No fishing expeditions, no drama. You want something? Put it in writing. It's a reminder that half these fights could be solved with a simple letter instead of weeks of court time.
And you texted me back saying it was okay. Their response was, that is correct. We apologize. We had forgotten about that. So this is not as simple as counsel seems to be indicating or would want it to be. The animal was approved by them, and I'm not exactly sure who the unauthorized occupant is.
And we are willing to put our proofs on the record as to who the unauthorized occupant is and the status of the animal not being authorized in the unit, Your Honor.
All right. So with reference to discovery, do you know specifically what you want?
I also want to, I'm probably going to be amending my counter complaint as well, Judge, because they had her vehicle towed off the lot. And so, but I'm going to be looking for communications between Section 8 as well as from the plaintiff, which probably could be obtained either from written discovery to the plaintiff or to a subpoena to Section 8, or both, one or the other. And then with regard to the repair, I'm going to want their maintenance records and their repair records.
Have you made the request?
He's not made any requests yet, Your Honor. And we are now.
That part is accurate, Judge. I will not contest that.
It's been almost 2 months in this case, Your Honor. We've had no discovery requests.
It's actually been longer than that. They've tried to evict my client 3 times.
All right. Well,
So
great. So the way I work with discovery, particularly in district court, is make the request. I think counsel knows how I work. If the request is unreasonable, you can just send a letter. If the request is reasonable, I expect people to comply, much like the disclosure, sort of an analysis of disclosure provisions. This is what I need. Get it to them and see where you are.
fair enough, Judge.
Okay. So how much time do you guys need to accomplish that? Yeah.
I'm going to be going your way, so I'll defer to you on how long it's going to take. I can have the letter out next week.
Your Honor, I'd say no more than 60 days.
60?
Yes, Your Honor, for the full bench trial. If Your Honor wants to keep it shorter, I'm more than willing to. I know this has been going on for some time.
No. How much time do you guys need to get all your paperwork together? Because then I'm going to set a final settlement conference.
I'm deferring to you, counsel, because you're the one with the records, and I don't know what it's going to.
Important legal nugget. Tequila Smith just waived her defenses and even the 56-day rule. That's like saying, yep, I'll pay no arguments. No delays. It clears the way for the landlord, but it also locks her into this deal. Unless she files something fast.
Taking your end to get it. I can tell you I can put the letter together next week. The question is going to be, how long is it going to take you to provide the records? And I'm trying to show you a degree of grace.
I understand.
Yeah,
And that's
okay.
why I said 60 days is because I think that's more than enough time.
To do what?
To have everything all
Build a
laid
house
out.
in 60 days. Look.
Your Honor, and then I cut it down to 21 days. And I mean, I'm trying to work with both sides here and nobody's giving me anything.
Oh, Joy, you being so nice to each other. Listen, here's what we're going to do. You're going to get your communication out. I'm going to adjourn this hearing out to September. Do I have the 12th?
Yes, sir, you do.
All right. I'm going to adjourn this to September 12th, 2025 at what time?
2 p.m.
2 p.m. We'll see where we are with discovery, where we want to go. And likely from that date, I'll then set a final settlement conference. And if we need to, after that, if we need to proceed to trial, we can. Yes, sir.
I have trial on that date, Judge, on a case that I do believe is going to settle. So
Where?
I am in circuit court in front of Judge O'Brien.
Oh, she said she'd wait.
As long as I can make that representation that you said that to her, Judge, I have no problem.
No, that was never said.
That's fine.
No. Okay. We'll work around that. If it becomes an issue, then just let the court know. figure it out.
All right, thank you.
All right, thanks, Gav.
Thank you, Your Honor.
Westridge Mobile Home Park versus Jessica Holloway.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff.
Your name?
Billy Hubbard.
That's right. You're defendant too. You're always here. So, all right. Okay. Where are we on this case?
Your Honor, I submitted a dismissal to the court. The amount's been paid off. I've been informed by my client that we're all set. The only reason I'd asked to speak before the court was there is an amount in escrow that we just need released to my client. And I'm trying to find the most expeditious way to accomplish that. But otherwise, you've dismissed the matter.
So your indication that it's been paid includes the $1,230.
Yes, Your Honor. That
escrow.
Yeah, the account should be settled. We just need the amount released to my client.
And then you do have some